Everybody, Rich with Prep You outside the bunker, and it's been a couple weeks since we've done this, but here is another firearm legislation update. And we've got a bunch of stuff to talk about. We're going to talk about the ATF brace rule. We're going to talk about PICO in Illinois. We're going to talk about a bunch of wins here and there, and some other legislation that's going on around the country, statewide and on the federal level. I've been seeing a lot of videos from the different committees in the House federal level, really getting after a lot of the government agencies and asking them a lot of questions like, why are you trying to make law when you're not the ones that make law? And where did this come from? And why do you want to make 10 to 12 million Americans, felons with just a recommendation? It's been really good. Josh Hawley, I believe, is one of them. I think that's how you say his last name. Has been really good. Jim Jordan, obviously, and a few others have really stepped up. So it's really kind of nice to see the Republicans coming out of their shell finally. There's one Republican that belongs in the shell, and the minority leader in the Senate needs to go, but that's up to that state to take care of that. But without further ado, let's get into some of the items. We've got a bunch of items here that I want to go over with. So let's talk first about PICO in Illinois, and that's the one with the gun and magazine ban. And I want to talk about that real quick. Really, nothing's been going on. There's been a lot of positioning back and forth between the plaintiffs and the defendants and different courts and stuff like that. But basically, the final scheduling, the final scheduled filings have been made in the Southern District of the federal courts in Illinois. And the next key date is oral arguments on April 12th for that. And then in the Macon County case against the Illinois gun ban brought by Representative Dan Calkins from Decatur, the plaintiffs are set to respond by April 13th, with the state reply by the 27th, and then oral arguments are expected mid-May. So that's what's going on with that. And then also separately, the state tried to hold proceedings in the consolidated state-level challenges brought by attorney Tom DeVore. But it seems pretty clear right now that it's just going to stay as is, status quo, until May 4th for a hearing in the Effingham County Court. But something really big with the Illinois cases is the fact that two Supreme Court justices in the state of Illinois, new Supreme Court justices, they are being asked to recluse themselves, to step aside when these cases come forward. And the reason being is they got major money from not only the leader of the House, but the governor of the state and many other Democrats, to a tune of $2.6 million in campaign contributions to a Supreme Court, which I'm going to read one of these articles for you, and you're going to find out that there's not many states that allow that based on a federal case. So this is from the Cook County Record, April 1st. Today. So lawyers representing gun owners from Macon County have formally asked the court's two newly elected judges, Democrats Elizabeth Rothford and Mary Kay O'Brien, to step aside from hearing an appeal over the fate of the state's ban on so-called assault weapons because the justices accept more than $2.6 million in campaign contributions from J.B. Pritzker and other prominent Democrats, and also pledged during their campaigns last fall to support assault weapons ban. Now, to me, that tells me right off the bat, you have an agenda. And I don't think, as a judge, you're supposed to have an agenda. But apparently these two ladies do. So on March 30th, attorneys Gerald H. Stocks and Brian D. Eck of the firms Featherstrom, Gaumer, Stocks, Flynn, and Eck of Decatur filed a motion with the Illinois Supreme Court requesting the two justices recuse themselves in a lawsuit which argues the new gun ban violates Illinois state constitution, which it makes a lot of sense that they would do that. In their motion, the attorney said, without recusal from Justices Rothford and O'Brien, they will be left arguing at a hearing in which they look at the table of the opposing counsel and see the leading cash donors, approximately $2,681,000 of campaign contributions to the justices. That's the other attorneys, and looking up at the dais to see the judges pledge to support the agenda at issue. Banana Republic type stuff? Yeah, kind of, right? Or Stasi, Russia. The motion asserts that without recusal, gun owners from Macon County and elsewhere in Illinois who are looking to the High Court for fairly hearing their cases will have their rights due process denied. All right, which makes a lot of sense. That is very true and exactly what's going to happen. The questioners notably included reporter Greg Bishop of the Center Square have pointed to millions of dollars in campaign donated by Pritzker and top Democrats to the campaigns of the Justices Rochford and O'Brien last fall. If you don't subscribe to the Center Square, do subscribe to the Center Square. The main reporter on these issues is Greg Bishop. He's really, really good. I get a lot of information from Greg and the Center Square, and he has brought this up time over and over again. And he has said, Pritzker, for instance, uses campaign fund and a personal trust to donate $1 million each to Rothford and O'Brien. Entities either controlled by or answerable to top Democrat lawmakers, including the Speaker of the House, Emanuel Chris Welch, he's my rep, and State Senate President Don Harmon, and donated hundreds of thousands or more to both justices' campaigns out of their campaign funds. Okay? So regardless, if I donate to one person, I don't want them sending money to somebody else. That doesn't sound very fair. Kind of like what the teachers unions are going through with Brandon Johnson in Chicago with the mayoral race. Teachers have put up a beef and are filing suit against the Chicago Teachers Union for giving funds to Brandon. And I'm sure, which means there must be a few Republican teachers, conservative teachers in the city of Chicago. Sorry, I digress. In all, Stocks and Eck estimated that at least a third or more of Rochford and O'Brien's campaign cash came directly from Pritzker and his Democratic allies. At least a third. All right. Their campaigns were also bolstered by millions more spent on advertising attacking Rothford O'Brien's Republican opponents from a political committee created by trial lawyers with strong ties to Democratic leaders of the Illinois General Assembly. I know I'm going a little bit into the weeds, but I think the more you read this stuff, the more you say, there's no way they can pass judgment on any of these cases. Even though Pritzker has repeatedly and loudly rejected the suggestions that either of them should recluse themselves from the hearing because he says it's ridiculous that he bought their votes. But despite Pritzker's hand-waving dismissals, judicial campaign contributions have long since been a sore subject for the legal community in Illinois and throughout the country. All right, this is very interesting. This has got Illinois written all over it and everything, we have more politicians in prison or have been in prison than any other state, I believe. In 2009, the United States Supreme Court decision Caperton versus Massey, in which the nation's highest court determined a West Virginia Supreme Court justice had trampled the due process rights of litigants before that court when he refused to recuse himself from a case despite having received substantial support for his political campaign from a businessman involved in the $50 million case. Sounds familiar? In that decision, U.S. Supreme Court said no one need to prove actual bias. Rather, it was enough, they said, that there was a serious risk of actual bias based on objective and reasonable perceptions. When a person takes a personal stake in a particular case, had a significant and disappropriate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case was pending or imminent. Despite the concerns from the Illinois legal community, the Illinois Supreme Court never adopted the rule change recommended by the State Bar Association. Instead, continued to leave it up to the judges to determine when recusal may be appropriate. Neither Rothford or O'Brien nor the Illinois Supreme Court have yet to respond to this petition. However, both Rothford and O'Brien declined to recuse themselves from hearing arguments over the abolishment of the cash bail, and both judges has already authored decisions on cases argued months before they arrived at the court, including a controversial and consequential ruling on the scope and reach of biometric privacy laws. If these two aren't pictured in a magazine or a dictionary under political appointees or justices that have their own agenda and aren't going to follow the law, I don't know of two that would be any more of an example. So there you go. Anyhow, let's move on. So anyhow, we'll see what happens if there's any recusal on their behalf. I really doubt it. And is it another avenue for the plaintiffs if it goes against them once they go up further to the Supreme Court, who already ruled on this, to even make it more in their favor? We'll see. Legislation updates. Illinois, HB 2795. Representative Greg Johnson filed HB 2795, which is an omnibus bill to help prevent veteran suicide. One provision in the bill allowed a veteran to take their firearms in a moment of crisis to a federal firearm licensee for safe storage. Okay, according to the Illinois State Rifle Association, and they said they reached out to some FFLs, but some of the FFLs felt, kind of puts us in a sticky wicket here. Okay, we can accept it, we can put it away, we can give them a receipt, but what if they come back the next day and they ask for it and then they commit suicide? Is the FFL responsible for giving them back their firearms? So I get it. So ISRA researched the issue and found legislation in Virginia that would have created a tax credit for the purchase of safe storage devices such as locks, gun vaults, and safes. The sponsors agreed to add an amendment that would create the Firearm Safety Tax Credit. This would be a $300 tax credit for the purchase of a safe, storage devices for veterans who are in crisis and qualify for the provisions of the Act. Eligible veterans that are in a duress of crisis and who have been diagnosed with PTSD or have expressed contemplating suicide, they would get a $300 refundable tax credit. Up to $5,000 is allocated for the $5 million is allocated up to this credit annually, and the program administered by the Department of Veterans Affairs. So they're still negotiating on this, and we'll see where it goes. My issue with this is, okay, and you don't even have to be a veteran to have PTSD. Firemen, policemen have that. From cases they've gone on, stuff they've seen over and over and over again. I have a safe. I have a full gun safe. I have smaller safes. I have a safe in my car. if I have it and put it in there, I still know the combination. I don't know how something like this is gonna help, unless they don't know the combination. Somebody else knows the combination, and anytime they want to use their firearm, they say, "Hey, honey, can you unlock my safe so I can go to the range and shoot?" So I'm not really sure how this works. It's a great idea. Anything that can help prevent suicides for anybody, military, police, fire, whatever, EMS. Um, that's great. I just don't know how it really works. So, all right, Illinois again. House Bill 1404 deals with domestic violence orders of protection and other orders of protection. One of the remedies in the law presently available to judges is to order the surrender of a person's FOID card and to make them dispose of their firearms to another person that has a FOID card for safekeeping during the length of the order of protection. All right. Under House Bill 1404, a person must surrender the firearms to law enforcement, and an order could be authorized without a person being present in court. No due process, basically. Aside from taking away someone's due process to be in court, current law allows the judge to order a firearm destroyed if the firearm is in law enforcement's hands and cannot be returned to the owner. This means if a person had to surrender their firearms to law enforcement and then legally lost their FOID card, a judge could order those firearms destroyed instead of turning them over to a relative. This is from the Illinois State Rifle Association. I got it on March 20th. That's when I printed it. So, as they say in here, can you imagine if your father or you have a very extensive and expensive firearm and your firearms were ordered taken away from you, weren't given to your family members or whatever, and the judge says, no, you can't have them back for whatever reason, destroy them. Does that seem fair? I don't think so. So that's something to be kind of looking at. All right. House Bill 1305, Illinois, the Task Force of Firearm Insurance. This is where politicians and people that don't like firearms want you and I that carry firearms to have insurance, have to have insurance on it. Okay. It would make legal gun owners carry liability insurance on their firearms. Okay, so number one, a lot of us do carry it, all right, for legal reasons and stuff. But for some, this would have placed unnecessary burden on them that they can't afford, which means they wouldn't be able to carry, which means they wouldn't be able to protect themselves, their family, or their property. All right, so ISRA had discussions with members of the insurance industry. Not only do they want to avoid this issue, but they don't even currently have a product for sale and don't want anything to do with it whatsoever. So we'll see where House Bill 1305 goes to. All right. Other side of the country, California. A few years ago, the state of California gave itself the power to make the California-approved handgun roster. Okay, what this roster is the approved handguns that can be sold or that you can have in the state of California. The fact that no new handguns have been added to this list in 2013. All right, again, this is from the Illinois State Rifle Association, March 13th ISRA Bulletin. So, a recognizable firearm, which is affected by, is the Glock 19. In 2013, the Glock 19 was in its third generation model and was approved. Since then, California has required new models that must have load chamber indicators, magazine disconnects, and micro stamping capabilities. The new fifth generation Glocks do not have any of these, and for a good reason. They don't have the loaded chamber indicators because tell somebody that you were loaded and ready to go. A magazine disconnect prevents the gun from firing the magazine if it's out of the gun. And that could be problematic in two ways. If you have your last round and you know it and you're dropping your magazine to put another magazine in, you can't fire that round. Or if you hit the magazine release by accident, your firearm is basically useless. okay? Because now you're scrambling around and your head drops to find your magazine and the perp is on top of you in no time, or still firing, one of the two. And then there's the fact that microstamping is a technology that does not exist. So the California Pistol and Rifle Association and others sued the state of California. The case is known as Borland versus Bonita. Bonita is the California Attorney General. U.S. U.S. Well, some of them are. U.S. Circuit Judge Cormac Carney issued a preliminary injunction against the California-approved handgun roster. The judge noted that policemen in California do not have to be armed with handguns that are on the list. He also pointed out that Californians have the right to the latest technology. This injunction will go into effect for 14 days, and that will give the state a chance to appeal. And then they will go forth with this case, and it's going to go to the Ninth Circuit Court of Appeals, and then obviously to the Supreme Court of the United States. So there you go. So there's a win. All right. North Carolina. Residents in North Carolina no longer need permits to buy handguns. All right. The House voted 71 to 46 to enact the bill, which eliminates the long-standing permit system requiring sheriffs to perform character evaluations and criminal history checks of pistol applicants. The Senate overrode Governor Cooper's veto in a party-line vote on Tuesday. The permit repeal takes effect immediately, and those who purchase pistols from a gun store or a federally licensed dealer are still subject to a national background check, and concealed carry weapons permits are still required. So there you go. Good job, North Carolina. Very, very good. All right. Florida. Words are hard. I should probably have a drink. Florida lawmakers send DeSantis momentous bill that would make majority of U.S. states constitutional carry. All right. The Florida Senate approved a bill that eliminated the requirements for individuals to obtain a permit to carry a concealed firearm, sending the legislation to Governor Ron DeSantis. The Senate voted 27 to 13, teeing up Florida to be the 26th state with what supporters call constitutional carry laws. This is from Fox News. I got it on March 30th. There are currently 25 states that have constitutional carry or permitless carry laws on the books, meaning Florida could tip the U.S. into becoming a constitutional carry majority country. Wow. Ain't going to happen in Illinois, California, New York, and New Jersey. I'll tell you that right now. So, way to go, Florida. That is flipping awesome. And it looks like, oh, and in Georgia is set to become the 26th state with constitutional carry laws, in a major win for gun rights activists. All right. But of course, the anti-gunners say it's going to cause more problem. More people are going to get hurt. You know, can't remember the Democratic congressman that was screaming in the hallways of Congress the other day about more guns equal more deaths. And I think it was Congressman Massey who came forward and said, hey, whoa, chill it down, dude. You're wrong. You need to check. You need to find out. No, more guns do not equal more deaths. It's the other way around. But the guy wasn't having it and just kept screaming. All right. From Fox News also, I published on April 1st, federal judge strikes down Minnesota law banning 18 and 20-year-olds from obtaining gun permits. Federal judge on Friday struck down a Minnesota law that prohibits adults ages 18 to 20 from obtaining permits to carry handguns in public. So, in the 50-page ruling, the U.S. District Court Judge Kathleen Mendez agreed. Relying on the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Brune, the judge concluded that Minnesota law was unconstitutional and blocked the state from enforcing it. So there you go, another win, and this one in Minnesota. And that is one goofy state, I got to tell you that. You know, that is crazy. All right, On the federal level, Senate Republicans introduced legislation to codify the Supreme Court 2022 landmark ruling in New York State Rifle and Pistol Association versus Bruin. They want to say any gun control law must have a historic tradition in order to comply with the Second Amendment, and it creates a requirement for the government to pay attorney's fee if an individual successfully challenges a Second Amendment infringement in court. There you go. Not bad. All right. And of course, Tennessee Republican senators introduced the Securing Aid for Every School Act, called the SAFE Act. It would give school grant money to train and hire veterans and former law enforcement officers to serve as school safety officers and provide funding to harden schools and increase physical security. And of course, when this went forward, Biden rejected it, said it's going nowhere, it's not going to happen. Well, Senator Blackburn, Republican from Tennessee, who put forth this bill with her other senator, stated that all the Democrats want to do is ban semi-automatic rifles. And she's right. That's all they want to do. They don't want to come up with solutions. This bill would be a solution, but it's, as of right now, Biden says no. My only issue with this one is it talks about veterans and former law enforcement agency. It kind of leaves people like me out of it, and others who never served our country, but are firearm safety officers, firearm trainers. Hopefully that'll get, if it comes out, it'll get tweaked a little bit. And there are a lot of people out there that know firearms. I believe that all schools should have people within their staff, teachers that are armed, that nobody knows about, because if they know who they are, that just kind of defeats the whole purpose. All right, we talked about earlier the ATF arm brace rule. There have been a lot of House rulings on this with the ATF. And I mean, it's been in your face against the ATF. But what I didn't know is that the main backer of this rule and colluding with our government is the group Everytown, which is a very left-wing Marxist anti-gun group that has been working very hard in passing anti-2A and actually trying to get rid of the Second Amendment for a very long time. Some of the questioning that was given by some of the congressmen, Republican congressmen, was basically, this has been legal for 10 years, and all of a sudden it's going to be illegal, and you're going to make at least 10 to 12 million Americans felons overnight. And basically the ATF says, yeah, pretty much. And something else I didn't know is where the brace came from. The brace actually came from a former veteran who developed it for other veterans who had problems holding pistols. And with the pistol brace, it allowed them to be able to shoot pistols. And that's where the whole concept came from. And it was perfectly okay. Everybody liked it. It was no problem whatsoever. Another problem with the ATF arm brace rule is that you have to be registered to be able to have this, okay? And it gives the government a list of people that have firearms, which is really not a great idea, you know. And it's another thing is it's to be retroactive, which means all the way from square one, which is technically illegal. You can't do that. And it's also a rule issued by an agency, not the Congress, which affects millions of Americans. And the problem with this is, so today they'll outlaw braces. Are binary triggers next? What after that is next? Scopes? Pistol grips? Where does this end? And that's what the Republican congressmen were really upset about. You know, and another thing that I found out with the ATF, and I think we've talked about this before in previous ones, is that the ATF and FFLs work hand in hand. They work so well hand in hand that they can find minor little infractions and they can shut down the FFL. Okay? What happens with the firearm records when the FFL gets shut down? The ATF gets those records. So the ATF gets all those firearm purchase records, plus they have all the arm brace records. And they can put this list together and they can use it, or anybody can use it at any time, which is kind of a bad thing, which has proven in different places that, and even the silly movie, well, it wasn't a silly movie, it was a cool movie, I liked it, Wolverine. If you remember Wolverine, when America, their portion, that which was Wyoming, got taken over by the Russians and the Cubans, they went door to door knowing exactly who had firearms. And how did they do that? They went to the gun store and got all the records. Okay. And in a case like that, and just like what would happen here, they are not going to go door to door to every single person that, you know, has a firearm that isn't turning it in or isn't registering. All they have to do is one here, one there. You start to think, am I next? Oh my gosh, I don't want to go through this. I don't want to have happen to me what happened to Tom or Sue or Sally. So you instantly turn in your firearm. Goes down a very slippery slope if you think about it. If you're thinking the way I'm thinking, it's not a good scenario. And this also goes along with the requesting of the merchant codes, the new merchant codes for firearm and ammunition. It was stopped, but the only reason it was stopped that was because 24 states attorneys versus 17 states attorneys who wanted it said, no, we're not doing this. This is not happening. And they stopped it. Somehow they stopped it. And as of right now, you purchase ammo or you purchase a firearm, you're not getting it. You're getting a general merchandise code put on that, you know. And the thing is that knowing how liberal some of these credit card companies are, all the government would have to do is say, hey, give me your firearm and ammunition coded transactions, and they would have that. And another thing that's interesting with the federal government, and Cori Bush, one of the squad, she kind of pushed her hand a little bit too far and kind of showed you exactly what a public health emergency looks like. You just saw it with COVID. Public health emergency, you got to get a vaccination. You got to get a booster. Got to wear a mask. Can't go to school, but you can go to a strip joint. You can't go to the grocery store, but you can go get your marijuana fix. What she's saying is, we will make gun violence a public health emergency. And when we do that, we will come after the firearms and we will confiscate those firearms. Not the smartest tool in the shed there, Democrats, but she kind of projected exactly what you want to do. And we know that's what they want to do, you know, because, you know, even Senator Warren said, hey, we are going to get these lists from these credit card companies had it gone through. And what if it does go through? And she still wants to get that list. And then they come after you. So that's why all these agencies are fighting all this. That's why our congressman, it's so important to not only vote smartly on the local level, but on the federal level to get the right people in there, support them as much as you can. Find out what your congressmen and your senators are up to, both state and local. And there's more and more wins for us because I think more and more people are tired of this. More and more people want to protect themselves. And people are fighting the good fight out there. One day you may have to fight that fight. I may have to fight that fight. But we need to stay strong, stay together, and know the people you can go to. In your state, there are lawyers and there are representatives that will help you if you get in a sticky wicket, shall we say. So there you go. There is your firearm legislation update. We'll let you know more, those of you in the state of Illinois, more about PICO as it goes along. Obviously, there's a few federal bills and other state bills that are coming along. There's some that I talked about the last time, which I'll do a little bit more research. I cannot thank Illinois State Rifle Association enough. I am a member. I can't help but thank Greg Bishop for his podcast and stuff, and the Center Square. Please sign up for the Center Square. Please become a member of ISRA. Also, Fox News, thank you for helping to fight the good fight and getting all this information out there. And everybody else that's doing the best. Don't forget Gun Owners of America. Stick with them. Concealed Carry Association. Please make sure if you're carrying, you do have insurance. It's your choice on who you go with. I'm beholden to nobody to tell you who to go with. So, and I don't make any money from any of these people off of any of this stuff. But I'm willing to if you guys want to be a sponsor. But anyhow, that's it for this episode of this. As we always say in our other videos, please be aware of your surroundings no matter where you're at, even if you're going out to get ice cream. And also have enough food, medicine, water, and ammunition. And as we've seen recently with the storms, you need that those supplies to have on hand for if you're going to shelter in place for months, if you're going to bug out for weeks. All right. And please prep like your life depends on it, because it really does. Thanks a lot. Take care. See you soon.